Hello everybody, welcome to Exam Coach. Today I am going to discuss some multiple choice questions on Indian Penal Code, and this is part 4 of my MCQ series on IPC. The first question is, which of the following is associated with common intention? These are the option, and the correct option is that is B. Premeditated concert is associated with common intention. Or common intention to us under section 34 of IPC. Common intention implies a pre-arranged plan, prior meeting of minds, and premeditated concert. The second question is, the courts have evolved some tests to determine at what stage an act or a series of acts done towards the commission of the intended offense would become an attempt. Identify which one of the following is not correct. তো ইয়াত কিছুমান দিয়া অপশন দিয়া আছে অপশনবোৰৰ ভিতৰত কোনটো টেষ্ট কাৰেক্ট নহয় ডিটাৰমাইন কৰাৰ কাৰণে যে কোনো এটা এক্ট বা সিৰিজ অফ এক্টস কোনটো ষ্টেজত আছে কোন এটা অফেন্স হোৱাৰ ক্ষেত্ৰত ওকে সো ইয়াত কাৰেক্ট অপশনটো হ'ব সি দ্যাট ইজ লোকাস টেন্ডি not the test to determine at what stage an act or series of acts done towards the commission of the intended offense. Okay, because locus standi is the concept which means what stand. Locus standi means what stand. The court asked a petitioner, by what right can you petition on this matter? It is not a test to determine where there is an attempt or not. Baki proximity test, impossibility test, and social danger. These are the tests through which court determine at what stage an act or series of acts done towards the commission of the intended offense would become an attempt. Proximity test or joite ki kora hai? Proximity test measures the accused progress by examining how close the accused is to completing the offense. Third question is, match list 1 with list 2 and select the correct answer using the code given below the list. Common intention is related to joint liability, because we know that common intention creates joint liability, and that's why we called section 34 as joint liability provision. Okay, next is the common object. It is related to constructive liability. Where the offense is committed by any member of an unlawful assembly in furtherance of the common object of that assembly, each member of that assembly would be constructively liable for the act if it is done by him, irrespective of the fact if he is present at the time of the commission of the act or not. Instigation is related to abatement, and dishonest intention is related to theft. So the correct option is that is A. Fourth question is, section 300 of IPC speaks of situation in which if a murder is committed, then it is treated as culpable homicide not amounting to murder. Which one of the following situation is not covered under section 300 IPC? So section 300 IPC কিছুমান সিচুৱেচনৰ কথা কোৱা আছে য'ত যেতিয়া মাৰ্ডাৰ এটা হয়, মাৰ্ডাৰটো কেতিয়া culpable homicide not amounting to murder হিচাপে ট্ৰিট কৰা হয়. ওকে, সো ইয়াত কাৰেক্ট অপশনটো হ'ব C, that is exercise of legal rights. Section 300 কিছুমান exceptions দিছে যাৰ দ্বাৰা কি ক'ব যে when culpable homicide is not amounting to murder. These are the grave and sudden provocation, exceeding right to private defense, public servant exceeding his power, death cause of the person consenting to it. Okay. Next question is, which of the following elements constitute criminal misappropriation of property? So the statement board is a kunbur statement order criminal breach of property to constitute kora hoba essential element hoy. So at correct option to hobo B, that is statement 1, 3 and 4. Movable property belonging to a person other than the accused. The accused must have misappropriated the property to his own use. There must be dishonest intention on the part of the accused. ইয়াত এটা কথা মন কৰিব, statement 1 আৰু 2 তলে চাওক, ইয়াত কথাখিনি একেই কৈছে যে movable property belonging to a person other than the accused আৰু any property belonging to a person other than the accused. ইয়াত আছে movable property আৰু any property বুলি কৈছে. any property বুলি কোৱাৰ লগে ইয়াত movable immovable সব ইনক্লুড হৈ যাব, কিন্তু criminal misappropriation of property must be movable property. Okay, Next question is, which one of the following is the correct statement? When two or more persons agree to do an illegal act or do an act by illegal means, such an act amounts to, that is, criminal conspiracy, or it was under section 120A of IPC. According to section 120A of IPC, when two or more persons agree to do, cause to be done an illegal act or an act which is illegal by illegal means, such an agreement is designated as a criminal conspiracy. A is the executor of a will of a deceased person. As per the will, the property of the deceased is to be divided equally between X and Y. Instead of doing so, A dishonestly divides the property of the deceased equally between Y and Z. A is guilty of the offense. So A executor asile, deceased person jon willer. As per the will, the property খিনি X আৰু Y মাজত equally divide কৰিব লাগিছিলে। Okay, কিন্তু সেইটো নকৰি পেলাই A কৰিলে কি dishonestly Y আৰু Z ৰ মাজতে property টো divide কৰি দিলে। এতিয়া A কোনটো offense দ্বাৰা guilty হ'ব? So he is guilty of criminal breach of trust. The executor is under legal obligation to follow the instruction of the deceased. If he violates the direction of law, he is guilty of criminal breach of trust. That is under section 405. Next question is, A sacrificed his son before his goddess, who according to him appealed him in dreams and asked for the sacrifice. On being charged for murder, he set up the plea of unsoundness of mind. Can his plea be sustained? তো এৰ সপোনত ভগৱান আহিলে, ভগৱানে ক'লে যে নিজৰ ল'ৰাজনক ভগৱানক উৎসৰ্গা কৰিব লাগিব, sacrifice কৰিব লাগিব। তেতিয়া তেওঁৰ এগেইনষ্টত মাৰ্ডাৰৰ চাৰ্জটো দিয়া হ'ল, তেতিয়া মানুহজনে কি ল'লে? আনচাউণ্ডনেছ অফ মাইণ্ডৰ প্লিটো ল'লে। গতিকে এই ক্ষেত্ৰত আনচাউণ্ডনেছ অফ মাইণ্ডটো ছাষ্টেইন হ'বনে নহয়? আৰু দিছ ইজ দ্য ফেক্ট অফ এ ফেমাছ কেছ। অ'কে, তো ইফ ছাষ্টেইন নহয়, নো, because he knew the nature of what he did or what he did was wrong or contrary. এই কেছটো সুপ্ৰিম কোৰ্টে কৈছিলে যে merciless acts, such merciless acts must be punished. The plea of unsoundness of mind was not accepted because the Supreme Court said that the act was done with knowledge that it was wrong, or at least that it was contrary to law. The nature of the act was not unknown to the accused. গতিকে unsoundness of mind যিটো plea লৈছিলে সেইটো ইয়াত sustain নহয়। Next question is, whoever by words attempts to excite dissatisfaction towards government established by law commits the offense of, that is, sedition. Or sedition to আছে section 124. AR sedition to আপোনালোকে মাজতে খুব নিউজত পাইছিলে, গোটেই কারেন্ট টপিকছৰ লগত ৰিলেটেড হয়। ওকে, কানহা কুমাৰৰ কেছটো হয়তো পঢ়িবলৈ পাইছে পেপাৰত। So section 124A defines sedition. আৰু ইয়াৰ ইনগ্ৰেডিয়েন্টছবোৰ হ'ল কি যে is to excite disaffection towards the government established by law. It may be excited by word, gesture, sign, or visible representation. Our last question is, X, a person above the age of 18 years, asks Y to shoot him to death as X is suffering from incurable disease. Y is the domestic servant of X. As a loyal servant, Y shoots X to death. In the context of the above, which one of the following statement is correct? তলত কিছুমান statement দিছে, ওপৰৰ যেটো context সেই context লৈ কোনটো statement correct হ'ব? X above 18 years এজন মানুহ আছিল, incurable disease দ্বাৰা suffer হৈ আছিল, গতিকে তেওঁৰ servantক ক'লে যে গুলিয়ে তেখেতক মাৰিব লাগে। তো servantজন যেটো loyal servant আছিল, তেখেতৰ masterক Xক shoot কৰিলে। তো এতিয়া তলৰ কোনটো statement ইয়াত correct হ'ব? তো correct statement হ'ব D. Y's act is culpable homicide not amounting to murder. আৰু এইটো আছে পৰিব আপোনাৰ under section 300 আপোনাৰ 300 or exception 5 যদি 5 to পৰে আপোনালোকৰ ক্লিয়াৰ হ'ব। So under section 300 exception 5 says that if death is caused with consent of the person who is of above 18 years of age, the culpable homicide is not murder. So why that ki hobo? Y's act is culpable homicide not amounting to murder. Section 300 exception 5 to sai lobo clear hoy jabo. Okay, so this is for today. Thank you.